The metalworkers union Numsa and the South African Cabin Crew Association aimed at stopping job cuts at SAA. Analysts say the layoffs will be key to reviving the fortunes of the cash-strapped national carrier, which is fighting for survival. But the two unions say SAA's business rescue practitioners appointed to try to rescue the airline are trying to push through job cuts without following labor laws. Let's get the reaction. Numsa spokesperson Phakamile Hlubi Majola joins us now live on the line. Phakamile, very good morning to you. What's your reaction, firstly, to this ruling?
Good morning, and good morning to your viewers. As Numsa and SACCA, we are truly shocked and disappointed that the Labour Court could come to such a decision. Effectively, what the judge said in his judgment today was that he does not believe that the business rescue practitioners at South African Airways are contemplating retrenchment. We find this so unacceptable because there is so much evidence to the contrary. The mind boggles, actually, as to how he arrived at that conclusion.
But how do you react to critics saying that this, in terms of the union's application, was purely a publicity stunt and you misinterpreted their statement?
No, that was a comment that was actually made by the business rescue practitioner in court yesterday. They had the audacity to go and actually say in open court that this application was nothing more than a publicity stunt. They have actually sat with us and discussed in detail about how they want an accelerated retrenchment process that is outside the Labour Relations Act. And as I speak to you now, they are busy implementing that retrenchment process. And what is really painful is that the Labour Court has endorsed this sham of a process. The very fact that, for example, the business rescue practitioners went to UIF to discuss ways of funding retrenchment. That's on the record. They said this. Secondly, we have recordings from our members where a Durban station manager outright told workers that as of the 1st of March, they won't have jobs because of the fact that they have cancelled routes. It is very clear that workers are being retrenched. They are being retrenched outside of a normal legal LRA process. And it seems that the Labour Court has endorsed this. And this is why we are going to appeal this decision.
Okay, so that's important to establish. You are going to appeal this.
In fact, as we speak, we're waiting to argue for leave to appeal. Yes.
All right. Apart from hearing through the grapevine in terms of there being retrenchment, what has been explicitly expressed from the business practitioners in terms of retrenchment? Because some are arguing Phakamile, that this is premature.
No. We didn't hear through the grapevine. On the 4th and on the 6th of February, I was actually present at one of those meetings. Mm-hmm. They said it. They said it with their own mouths. So what they actually did in court yesterday was to lie. That's what they did. And they did so even though we provided evidence to the contrary. There was Clute Murray, who was present in one of those meetings. You know, Clute Murray is a well-known business rescue practitioner. Mm-hmm. He sent a stinging email to the business rescue practitioners, cautioning them on the fact that they are discussing retrenchment outside of a process. He cautioned them on the fact that they were not engaging meaningfully in these discussions, and it seemed as if workers were being railroaded. That we submitted as evidence. So for anybody to come and tell the public that we imagined this, they're lying, and there's no other soft language to use. And let me give you a very clear and practical example. There is no way that anybody can believe that workers are not being retrenched when we already have a decision that's been taken that as of the 29th of February, 11 routes will be cancelled. So let me break this down for you. On the 1st of March, what will workers at KZN, PE, and East London do? If they're not being retrenched, what will they do? Will they come into a workplace that no longer exists? This is the point that we're making when we say that we find it completely outrageous that anybody could argue that retrenchments are not taking place when a decision has already been communicated to the public that 11 routes will be cancelled. What will happen to those workers? Will they sit in the parking lot of the airport? And I think as long as yes, the BRPs cannot give clear answers on that, then you must accept that what we have put on the table is the truth.
With regards to the cancelled routes by SAA, what do you make of government's approach to this? They did express a view, but it must go back to the point that this was a volunteer business rescue. So in order to go to the court, I guess there needs to be a high bar set in order to get the business practitioners to change their mind.
Look, I think we want to make it perfectly clear that the reason we went to court was we wanted to enforce our rights as workers to genuine and meaningful consultation. Let me explain. In a Section 189 process, when you're being retrenched, a company has to give a very detailed financial presentation and explanation, explaining why restructuring has to take place. In those consultations, labor is afforded an opportunity to provide alternatives which the company has to consider. So what is happening to us right now is that the business rescue practitioners are proceeding with retrenchments and restructuring. We are not being afforded the opportunity to engage meaningfully. We are simply being railroaded in this process. And this is why we came to court. We came to court in order to try and protect our rights and the rights of workers so that we ensure that they don't suddenly wake up, as they will, on the 29th of February and arrive where there is no workstation after routes have been cancelled and we don't even know what's to happen to workers after that decision has been taken.
Phakamile, correct me if I'm wrong. Once you go down the business rescue route, you temporarily give up control of it, right? You can't necessarily dictate to the business practitioners what to do, and considering this is a voluntary business rescue process. I want to understand in terms of these committees that often are formed with regards to the business practitioners and as they, take forward their work. Are you part of that committee in terms of consultation?
The law with regards to business rescue practitioners is very clear. They have to engage meaningfully with all stakeholders. Labor is a stakeholder. We were not engaged meaningfully at all. That is the nub of what we're saying. And this has been clearly demonstrated in the last 2 to 3 weeks. I think that's the first point. Secondly, the business rescue practitioners are not a law unto themselves. And this was also highlighted yesterday in the argument. Business rescue practitioners don't get to just wake up one day and decide, and the law does not allow them to simply retrench workers. They have to still be subject to the Labor Relations Act. And ultimately, this is what this application was about. It was about forcing them to understand that they are not sheriffs out there in the Wild West acting unilaterally, doing as they please. They have to operate within the context of the South African Labor Relations Act. So now that it's become clear to us that unfortunately the Labour Court does not share this view, we will then continue. As we said, we are going to appeal this decision. We're waiting to make our arguments now. And if we are denied leave to appeal at this lower court, we will then petition directly to the Labour Appeals Court for an audience so that we can ensure that our rights are enforced.
Just finally, as we wrap up, Phakamile, have you managed to brief your members with regards to the latest developments here? Any reaction from them?
As I speak to you, our shop stewards are in the process of updating members and trying to explain to them what the situation is.
All right, let's leave it there. Phakamile Hlubi Majola from Numsa, thank you very much indeed for your time. Basically giving her reaction with regards to this breaking news. The Labour Court dismissing a joint application by metalworker union Numsa as well as the South African Cabin Crew Association aimed at stopping job cuts at SAA. Stand by, we'll try to get more reaction with regards to this breaking news.